that's good. Better.
I found out too with the relaxation of the change control,
Mhm.
as of last year, you can have a US.
Oh, okay. When they publish that?
It seemed to this late last year, early this year.
I thought that was for the payments over here. You can do the
But I thought
100,
that was for
like over here,
companies.
over here.
I was
Not-
told that she could,
Cause the one where we got with the relaxation is that companies under $100,000
Right.
don't need
Yeah.
central bank approval, but they
Right.
can come to the bank with what they need, and the banks can now approve it. But I don't know anything about individuals.
Because I thought they said
I
companies.
just
Yeah.
asked if we needed, I'm gonna ask it.
Yeah,
Yeah.
that's where it is, yeah, because it's
Yeah.
individual
Yeah,
versus a
individual.
corporate account.
Mm-hmm.
So you're not off the hook yet.
Yeah.
Whatever it is.
What you mean, whatever it is?
But before we start, when we get started, I have two questions.
She has something to go ahead.
Okay. I have a question.
No.
Oh, go ahead. Okay. When we were talking last week, about, coming in to open up the documents and everything, two sets I wanna get clarity on. Now we have these, not these lawyers, we have lawyers who come into the bank to open up accounts. And they have their personal law firm. And so they are treated as trading as persons.
Mm-hmm.
No, that's my question, because some of the documents that we end up asking for, well, we have one of the lawyers, she said they don't need to get all of those things. All they need to do is get a business license, because that's what they're required by the Bar Association. And that they'll get, the only thing they basically will have is their business license from it, and we treat them as a trading as. But I just wanted to confirm if that's
So they're
true.
doing it solo.
Anybody could do a trading
Yeah.
as.
No,
a
I'm not-
trading as means you are sole proprietor of your business. So when you're sued in your they would
In
say
your personal capacity.
Roberta Quan trading as T&G. If I call my company or I use a letterhead that say T&G, but at the end of the day, I 100% responsible for what happens. The trading as doesn't limit your liability or anything. It's you as
No.
an individual.
No, that's
Unless
not.
you have
No, that's not
professional
my
indemnity
question.
insurance.
What was said to us by one of them is that basically that's all they can have.
But when you trade it as, you don't incorporate. So
No.
there's no memorandum
No,
or
yeah, and
articles or
understood.
anything.
No, you
Knowing the difference, my
Right.
question just is that can they do it? Can they go ahead and if you're a lawyer and you said, okay, I want to open up this company, or do you have the ability to then say, okay, I want to incorporate my business and form this if my business is a law firm other than in the name? Okay.
Anything.
No, someone made it seem like they could not do that.
Oh no, you can if you choose to set up your law firm as a company, you can go ahead and do that. It's your choice on whether you just do as a trading as. A lot of the smaller firms just do trading as rather than incorporating a company,
that-
and what they do is they get indemnity insurance, which helps to cover their liability if something happens.
No, because what happens, we had a case where a person came in and they had it trading as their name limited at the end. Okay, so you see what I'm saying? So they had it trading as, let's see, my name is Katrina Pinay, did it as, I'm a lawyer and I do Katrina Pinay Limited. So they had the limited behind their name.
They shouldn't, but they're not incorporated.
You see,
Normally,
so
if you're
then-
not incorporated, you
can't
should
use
not.
it.
Thank
You're
you.
not supposed to
So
be
that's
using
where
limited.
we got into the discussion with them, and she's like, "No, this is a trainer." So we were like, "So why did you put the limited now behind this name?" Oh, we have to do that. The association that's here, and they started with one story. So I said, anyway, I just get some sort of clarity as to say why you would put that limited behind your name if you just a trading act.
Don't answer her own question.
Mm-hmm.
Where in the act it says you must use LTD or limited. Don't answer her. Let her go. We'll wait for you, then I can answer Ingrid, because Ingrid question is for everybody.
Right, that's
Oh, in which chapter?
the one we're gonna do this.
Oh,
Yeah, I think we can do
I let her find her answer.
this. I don't understand this.
Hey, come on.
I didn't know there could be.
Hello?
Hey, how you doing, Rico? Okay, we good?
I can't see though. Okay, I can see.
All right.
Okay.
Is it what?
Still not so light. Getting warm? You finding it? I'm talking about the temperature. I don't know you.
I think I checked section 14, that's what I'm reading. Exclusion of limited from the name of companies.
What does it say?
Well, there's 90, so I just want to get to the
Get to
specific
the
part.
point.
Mhm.
I like my new one. Hmm.
It still don't make that distinction though.
Because I only see 14 where it's saying that the minister may be licensed authorized, that the association may be incorporated without the word limited in its name.
Mm-hmm.
Section 5. The name of proposed company of addition. A, the name of proposed company addition of the word limited. Okay.
Using the new one, I like my old one. I so used to
Okay.
finding things in my old one.
And it's,
12.
You need to post it? Yeah, you have to tag the pages.
which one you looking at, the new one?
No.
But that's 13, say subject to section
13.
14. Yeah, the word limited or the abbreviation must be part of the name of every company incorporated under this act with limited liability. But a company may use and may be legally designated by either the full or the abbreviated form.
I know what I think. I know what I think. Okay. Is referring to the amendments. They use the name of the company in other languages.
I found
That's what the regular.
particular name your company, the foreign ones, they don't have to have this means, they can put it in any language and you don't have to translate it. Eligible name, and if you are newly amended, your thing, yeah, I haven't read it yet. This is so fancy. I can't read that. Did we get that from English? Or just the consolidated one? But mine is the one with all of the amendments all over the place.
But you just have to accept the changes and everything.
Well, Fluid,
Oh, yeah, just
Miguel
accept.
probably didn't accept the changes
No,
then.
maybe, that's what I did,
This is
accept
all-
the changes.
'cause it's
But
hard-
you don't see,
it's hard to
is that
read
one,
it.
but he printed, it wasn't good.
So he
Yeah,
needs to
just
accept the
just
changes.
accept the changes.
But we don't have the electronic copy.
So let me
Still
let him send it
accept
to you all
changes.
electronically, so
Okay.
you can accept it.
Yeah, I thought he sent it last week.
I thought he sent it last week.
Yeah, I got it
I
last
don't
week.
have no emails from you.
It ain't bouncing in the
don't.
trash.
I don't know.
Or your
I'll have to
spam.
look.
Look, see if it went in the trash before I go and rob him out. Okay. What you gonna say? Oh, your question, yes?
I found 13
Mm-hmm.
was said that the word limited or abbreviated must be a part of the name of every company incorporated under this act
Mm-hmm.
with limited liability, but a company may use and may be legally designated by either the full name or the abbreviated form.
Okay.
And
And so if you're trading as, are you authorized to use limited?
no.
No.
Mhm.
You have to be incorporated
Yeah.
under the Companies Act or the IBC Act.
Sorry, I don't have it. It's not
You didn't
in
have
my
it?
junk.
What's your email? Let me get a piece of paper.
Give it my personal.
The CNA, it wouldn't be on here.
That's
Right.
my work email.
Hold on, right on the back.
Yeah, those are the things, so I'm not gonna work emails.
Yes,
Like,
yeah, a lot of people have that
Yeah.
issue. Sign in the front.
Yes.
So you can get it too.
Nothing like work email.
DANEAL? Okay, alright. So hold on one second, let's see. Okay, he's gonna send it. Did anyone else need a folder? Cause these folders were from last week.
Shari needs one, but she isn't here.
You do?
Yes.
How you feeling? We forgot. We miss you. Alright, so you clear now,
On that, yes.
in general.
Yes, like I said, the only debate became with us and the client,
Mm-hmm.
cause they were saying they were trading as and they were using the limited behind their name, and they were trying to tell us that they're only using the limited behind their name because they're using their name as the company, but they're trading as, and
No.
so, yes,
No,
so.
no. Everybody understood what that means, right? And she's a yeah, but how they had to come up with that story? This is an attorney,
Yes.
as if by putting the word LTD behind her name limits her liability. It doesn't, because the company is not incorporated. It's a trading as. Okay, hold on. The next thing you do before we start the chapter, everybody pull out your capstone. See if you have any questions. No, pull it out, 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 read it. If you haven't read it. No, same one. Miguel, why is this?
Yeah.
She's dropping or what? Bring me the register when you finish, please. What?
I want to make a copy of it.
You don't have one either? Okay, let me do it.
Please.
This question seem all over the place, eh?
You got to dissect it.
Very good. Yeah, you can do it, but I mean. No, I mean, yeah, that's what I'm saying. Because I'm wondering if she wanted us to compare. Were you here with Carol when she said that the return is not changed? Oh, no. It's changed to the 27th. Which month? Of October.
Very much. A few days off.
So what we would have had on the 27th, we will have one, the 20th, and have the return on the 27th. documentation. And on the 27th, you have the midterm exam.
And on the 20th, what you call it, shareholder.
On the 27th, you have on the 28th.
Oh, okay.
You doing the exam on the 27th, right?
No, I'm not gonna be here, so I gotta be do it that week.
Twenty's not far from here. Thank God you better tell the 27th. But I still have a big, my cousin a big weekend.
No, she give us this, the IBC.
You all who deal with this thing, you all better this is for what
Yeah, they were tasty. Maybe one, but I think maybe one or two of the chapters. Yeah.
Yeah.
Because you see the documents, but some of the
The
documents
lady
you
said
see.
it, except
Yeah,
for
like, you know, I would love what to see, but you now getting like the clarity on it, but. So the exam will still be on units 1 to 5 though?
Yeah.
Okay.
I wouldn't do that to you. Ran out of ink, so I don't have the second page. Well, let's go. What happened? You don't have it either? Oh, oh.
he emailed me.
He emailed it to me.
Yeah. So now you tell him bring two. Alright. So Ingrid raised the question, we can go over the capstone, but let me start with Ingrid first to see what questions you have or it's just general.
Just general, because it seems as if, the question seems as if it's all over the place.
Yes.
So I just want a general idea of what you want from us.
Okay, alright. So when you read the scenario,
You see some things.
you see some things that jump out at you.
Right.
Alright, so let's start with the first paragraph. What is the first paragraph telling you? Not the instructions now.
The first line of the agenda,
Hmm?
it gives you the overview of the business
Right.
and, asks you to advise on certain scenarios.
Mm-hmm. Using.
And then you'll have to, it gives you all the supportive documentation you'll need in order
So
to
you
support
either
your.
use, right, so you'd use the Companies Act or the IBC Act and any other case law that you have. Alright, so what's the next paragraph about?
What was the resolution? Okay, so it just tells you who the board is. It gives you the board of directors, who they are.
The board of directors and the shareholders.
And the shareholders, so you now know who the board is and the shareholders.
Okay.
And in the next paragraph, it says, this basically gives you an idea of what they want to propose with the shares, how they wanna, what they'd like to do with the shares, basically.
Mm-hmm. And so now you have to give advice, can it be done?
Yeah, and what would be best practice
Mm-hmm.
based
We have
on
that?
legislation and
Mhm.
based on whatever, I guess, experience you have as a director.
Well, we know once a company is formed, the shareholders issue what?
The shareholders agreement.
shareholders agreement,
Agreement.
and that's what the board follows. So now they're having their agenda, and this is on the agenda, so now you have to give advice as to whether or not this act can actually be carried out. And if it can, what changes?
Okay.
Now notice, if it is a regulated entity, then the last sentence is something you have to consider. If it's just a regular company by private investors, then you give a different answer. If it is a public entity with that last sentence, something else you have to consider.
So what you mean by regulated versus?
But it is a regulated entity.
Well,
Not
if
just
it's a-
leave it out, yeah,
because it says bank and trust.
Yeah.
It has to
Uh-huh.
be
It's regulated by.
Yeah, but I don't wanna give you the answer, I just telling you.
Okay, okay.
I leave it up to you.
Cause my first, I would seeing like that, I would probably go to see what it says, about due diligence, and maybe, I know the bank and trust, the AML,
No, you won't go to the AML.
not
That you better
AML,
go.
the bank and trust guidelines in terms of acceptance, due diligence, what brings the lightest for cognizance to serve present time.
But you're not going to the AML guidelines. Oh, thank you. What you gonna ask me?
How is it supposed to work?
That's what the
We can
question
hear
is, it
questions.
is.
We can.
She say, how do you know it's
Regulated.
It's regulated, like how we
Because
have
it's a
some
company.
companies who under, let's
Remember
say
when
for
I said
example, banks
regulated
report to
companies?
central bank.
I said, depends on the business that you're in,
Uh-huh.
it determines whether you're regulated or not. So, how many regulators do we have in the Bahamas?
I have no
Okay.
idea.
I think we have central bank, we
Central
have.
We have Central Bank,
Securities Commission.
Central Bank,
Securities.
Securities Commission,
We
the
have
Insurance Commission,
The
the gaming,
Compliance Commission.
the Gaming Board, and the Compliance Commission.
And then in order to open up a bank and trust company, you have to have a license
You have to go here,
to central
Central
bank.
bank.
Mhm.
So
But
then
I
that
see-
means that
What
it's
city?
regulated.
Central Bank of the
Central Bank.
Bahamas,
Securities
Of the
Commission.
Securities Commission, the Insurance Commission, Gaming Board, okay, Insurance Commission, Gaming Board, Compliance Commission. So I gotta put the question under any one of them.
Compliance Commission, I'm sorry, it's the first thing I'm hearing about it. Where are they? Under Central Bank?
No, separate,
Independent?
independent,
Where they are?
right on Shirley Street, where the Registrar General office, and they would regulate lawyers, real estate firms, accountants, they fall here.
Okay.
Who don't have the capstone? We still bring it capstone.
Someone else.
Yes,
Pop up. She need one up front, I say,
Oh.
yeah.
I don't know what this other piece.
So
No, no.
bank and transfer and
Yeah,
So,
the,
central bank.
Yeah. Yeah, she didn't schedule.
So okay, Central Bank, Insurance Commission.
Securities Commission,
They approve.
Security.
Central Bank of the Bahamas, the Securities Commission, the Insurance Commission, the Gaming Board, and the Compliance Commission. They're all regulators. Ah, she's in. We're in. Hello. We're going over the capstone. You got it? Yes. Okay, all right. So what we said was the first paragraph just gives you an overview, more or less the instructions. As you read each paragraph, each scenario, you have to give advice or recommendation based either on legislation or case law or best practice. Alright? So the second paragraph gives you the shareholders and the directors. The third paragraph tells you there's an item on the agenda. Now you have to give advice as to whether or not this can actually take place. Yes or no, and why. So the point was already raised in class that this is a regulated entity. So we just stopped to the point as to where to go to find the information. Right. So the question was raised as to how many regulators we have. So on the board, I know you can't see it. I put the Central Bank, Securities Commission, Insurance Commission, the Gaming Board, and the Compliance Commission. Get them all?
Gaming Board, Securities Commission,
Central Bank, Insurance Commission, and the Compliance Commission.
okay,
Right. And each one of these have their own website. So we've chosen a bank. Like I say, it could have been any one. So, when you read that last line, it says you are in possession of a document which confirms that Carlton has served time in prison for fraud. So you have to decide now what actions you're going to take. So you said go to the AML guidelines, and I said no, that's not where to go. You go into the Central Bank website, but not to the AML guidelines. What you gonna look for? You said the right word, due diligence. No,
No, I know that.
no.
The directors. Is the name of the
No.
document?
Yes, a document in there. It's due diligence, fit and proper.
You have to see it whether
Fit
they
and
fit
proper.
and proper
Yes.
in order to serve as a shareholder of a bank.
Mm-hmm. Yeah, but if you were running a company and someone has been charged with fraud,
But what I would have.
you could have used the word due diligence, which I said was correct.
But I would have gone back to the act and looked for his duties and what requirements.
No,
you
we're
wouldn't
talking
know
about duty now. Is whether that
that?
person
Okay, fit and
It's
proper.
fit.
is fit and proper to carry out that function.
Okay.
This could have been embezzlement. He could have, instead of serving time, just paid a penalty. You have to decide, is that person fit and proper to carry out this function?
You can't have someone who's involved in crime owning a bank.
No. And remember now, if you go back to what she just said, when you look at the duties, remember, when you become a director, there are fiduciary duties. The fiduciary duty means that you're in a place of trust. So how can you trust someone who has served time for fraud and embezzlement? Okay, so the next paragraph, what is this one telling you?
Well, whether or not, he had the authority to sign the documents, of guarantee for the bank.
Mhm.
If he has that responsibility.
Authorization.
Mm-hmm. And then the next one. Prior to the fourth quarter meeting, you noticed that the meeting procedures were not in order, and you scheduled a meeting with the corporate secretary to point out these matters. You have prepared a slide presentation to discuss the following. So where would you get these from? You get it from the legislation, because in most instances, the memo and acts copy what's in
What's in them.
the legislation. So at the fourth quarter, you're excited to make a presentation under any other business on the duties of directors, as one of the former directors is being relied on heavily by James and Benny. you've highlighted the statutory provision, but based on research, you would like to propose that these provisions be expanded to include more modern directors' duties. So this one requires you to do a little bit of research. But the first sentence leads you where? It says one of the former directors is being relied on heavily by existing directors. What is?
The Jody is.
Yes, about duties of a directors, but when you say a former one is being relied on, what are they talking about? What is that leading to?
Influence, like.
Influence, yes, yes. And then the second sentence asks you to do a little bit of research. So when it speaks about provisions being expanded to include more modern directors' duties, do some research to see if there are any other Commonwealth jurisdictions that are seeking to propose amendments to their Company Law Act to make it more modern. Because we have not changed our duties from the time it was enacted.
Is that a word count requirement or anything? Word count?
No, no word count. So another item is on the agenda. Look what I put, alteration. So this one is on capital and shares. Prepare a summary in the ways in which a company limited by shares may alter its capital, and also how to reduce capital. And then the last one is supposed to discuss the role and the power of the liquidator in winding up process. Isn't it easy?
So this sounds like a big book, doesn't it?
Yeah.
It's not here. What's wrong with your face? There's no word count.
Usually how many pages you get then?
25, 20, yeah. Normally about that amount. Because like sometimes if the students, like say when you do the research on the director's duties, that every class had different questions. But I'm saying there's always a point in it where you do some research. So normally what they do is if they find something, they would, instead of like putting it all in it, writing it all out, they would say, let's say New Zealand. New Zealand has made proposals to amend their company laws to include this based on this what happened. See appendix so and so, and they just print it out and attach it to the back. Instead you sitting there retyping it, rewording it, and taking a lot of time. And that's how they do it. Okay? Don't wait till the last minute to do it. How many points it worth? Oh, it's not on here? In the book. So we have a newcomer, so let's briefly go over what we learned. It's good, because guess what, the midterm is coming up fast, approaching. And then we'll do company incorporation. Chapter 1. Yes, 15%, that's a lot. Yeah, but who wants to be? Alright, let's start with chapter 1. We have our newcomer in the back, as he should turn the blank pages. Now, what did we learn in chapter 1? Don't go flipping pages, because she has to read for herself. What did we learn in chapter 1?
What is a company? How the principle of a company started to the case law done, what is done.
You listening? What did she say? Okay.
What is a company and the principle of how the principle of a company came about. with the support of the K Solomon versus Solomon.
Mm-hmm.
And our companies are separate legal entities.
Right.
We also learned about the advantages and disadvantages of the sole proprietors, the
Partnerships.
partnerships, and the companies.
Mm-hmm. So you can see all those questions coming up, right?
And also about listing the corporate bill when, in instances when it happened or when it didn't happen.
But what happened and didn't happen? What happened and didn't happen? What's this? What happened and didn't happen?
If the company is a facade, that's one of the times when they would list the corporate bill.
Acting as
If
an
it's-
agent.
Yeah, and that's it.
Mm-hmm.
When they decided there's a group of companies,
Mm-hmm.
then we learned the cases.
What's the case for group of companies?
If you let me flip one page, I know I
Yeah,
can
let's
find
flip a
that.
page. Flip a page. Flip a page.
Let me tell you.
Flip a page.
DHN for distributors. Then the one for agency as a parent. That's Smith Snow, SSK in the Birmingham group.
Mm-hmm.
Like she said, it's a mayor facade. What statute, like if the government passes an act, I don't know why that might have to
Where you
look
get
in
that
my
from?
I know, so that's why.
I know that on the board.
Yeah, say the government or if it's mandatory by law to
That's
the
what stuff
statute
is.
is.
That's what-
Yeah.
Uh-huh.
Mhm.
By law.
Yeah.
By law.
Okay.
Mm-hmm. All right. So what's the job to do? She have plenty reading to do.
Types of companies. Chapter 2 types
Types
of
of
companies.
companies.
We have the private and the public. Then we went on to say that if it's by shares
Mhm.
or by guarantee, and guarantee means that it would, they have basically an agreement that at liquidation or winding up, what the responsibility of what
The liability.
the
for
liabilities
each shareholder.
each shareholder would have.
Mhm.
Then you also have the hybrid, which is a combination of the two,
Shares and
shares
guarantee.
and guarantee.
Mhm.
I
You have statutory companies.
Yes.
Uh-huh. An example.
The statutory.
Mhm.
I ain't say statutory. Whoever says statutory.
Isn't like, BTC and what?
That's a
No.
stock.
Oh, okay,
Segregated
yeah.
company.
Yeah.
Segregated
What
company.
is a statutory company?
We,
Segregated.
Oh, it's segregated.
I
Segregated.
think we talk about them
You
being.
incorporate a company and then you have it registered under the Segregated Company Act.
Okay.
We
which
talk about
means that
mutual
each
funds
account
or
is
something.
limited.
Yeah,
Yes,
mutual funds.
uh-huh.
Okay. Yeah.
Stop eating our latest when you come here.
It keeps me.
I went in the office yesterday and I wanted an hour and later. I said, who hooked me back on these? You. No. Not eating now or later. Chapter 3.
We spoke about due diligence.
Mm-hmm.
We also spoke about what was or what is required to open up the bank accounts from a company level, from the individual levels, that due diligence and enhanced due diligence and money laundering, and why the documents important or were the documents suitable.
Mm-hmm.
Yeah, she said it. She said trust accounts.
Yeah.
We also spoke about the POCA Act. POCA as to say that some of the fines with, I think, tipping off,
Mm-hmm.
and not actually doing due diligence. That is not, the act was revised this year, and basically it not being to the point where it's just business as usual, like you accepting things from persons and not asking questions that you'll be held liable to. You'll have a fine.
And that's only the MLRO or something like that would be
What?
responsible.
No,
I'll say everyone now.
everyone.
Then we spoke about the MLRO and stuff going to the FIU and what's their responsibility and how the FIU could come back and ask for additional information. And if the
What's the FIU?
Financial Intelligence
Unit.
That's the one.
And
So
how
where is that housed? Yeah.
Norfolk House, Frederick Street.
and if they have enough
Second floor.
information or whatever.
Where's our second floor? One
You
of the
said
floor.
financial.
FIU Financial.
Financial Intelligence Unit.
And then the entity you would
Report
submit the
suspicious
suspicious
transaction
SDR
report,
to.
yeah.
And, okay, just for clarification, because you said all employees, in the event that something comes across your desk and you don't report it to the MLRO in your company,
You'll be liable.
you will be liable, okay.
I have a question.
Go
I
ahead.
know we were reviewing, but when we just talking about the documents, to go ahead and open these holding companies. When we speak about these holding companies, and they will go through the same process as they incorporate their name and everything, and then, but it would be in their memorandums as I say they are a holding company. So the only thing they would not basically get is a business license. They would not obtain that. When we compare that holding company
It
to a
depends because
regular-
most memo and ask are just general. They don't specifically say, I am only going to buy cars. They don't do that. Cause then you limit it.
So how is it that if me as a banker, someone is coming and saying, okay, I wanna open up this account, but I have a holding company, how would I know or do my verification as to say that this just actually is a holding company? Because you have some of them who come and then the reasoning is, okay, I'm just a holding company, so I would not have a business license. So how could you confirm that?
From the financials.
Mm,
The financials.
okay.
Because you won't be able to tell from the memo and acts.
Okay. you'd
So
have
you
to
need
ask
the
them for
financials.
Okay,
And then in the financials, you'll see it's just holding assets.
okay.
So that's how you confirm the business activity
By the
through the
financials.
financials, and then,
You supposed to do something else.
no, I was thinking about like when you open up account for a holding company or funds, they ask you for the source of wealth. Where
That's
did
it,
the
but there's
business
sometimes these are
owner-
new companies.
Yeah.
If this is new,
No, I mean, even if you go to
Yeah.
open up a bank account on the most bank account forms, if you open up a bank account for investment or a holding company, most times the bank account, they'll always ask you the source of wealth. They need to know the initial funding. Is it coming from the person who owns the company, or is it coming from a
From
client
other
of the
companies or
company?
companies underneath.
So if it's like, say if a client owes you $20,000 and you want to open up a bank account, you could use that money, but you'll have to provide support to them to say, well, an invoice to say you bill them for a certain amount of services.
remember now, that's for someone who's already established. You could be new. You could have a new company just going into business. You could say this is a holding this is what my intent is, so you would not have a lot of those
Or you mean for
documents.
just
Right.
a
That's
new,
what you know,
a new
so-
bank
But
account?
as the
Yes.
relationship continues and you see movements,
So
then you
that's
need to
what I'm
ask
saying,
for
that
more.
Well,
my
in that
question
case, they
basically
probably
is that
would
if
ask
you
for a
are a
business
brand
plan.
new company, and you're saying that this is a holding company, which intent, my question basically is that what type of documents we could look at from the initial stage if you are new and this is what you're saying?
You probably ask them to have their auditors provide you with a statement
Something.
for what
Okay.
they're holding.
Okay.
Cause they would have only just, when they incorporated the company, put those assets underneath it.
Under them.
Until they start doing business, then you wouldn't know. Cause they're most likely they will form subsidiaries underneath.
Underneath them.
That'll be the operating companies.
And when we have like annual reviews, to be able to follow up at a later date.
Yeah, from the bank
that,
side, yeah.
Yeah. But that's if you want to, if you decide to
If you
take it
on
on.
the business, yeah.
Alright, so we all know. You happy now? Talk this. 3 chapters. And you had the flu. Stay in the back there.
I know.
Alright, so let's talk about company and corporation. And everybody have their acts ready. So what documents are required to incorporate a company under the Companies Act?
The memorandum, article.
The memorandum and articles.
You share register? Sure. Okay.
No.
Okay, should I register for the register? Directors and officers? No?
What'd you say?
The register of directors and officers?
Incorporate? Yeah, further down, but let's start with the first document. The
Memorandum
memorandum.
and article of association.
What is a memorandum?
It's a document, that provides the. It's a document.
I hear them whispering. What's a memorandum?
Document which contains the fundamental provisions of the company.
I see that.
Its official name, the type of company, registered office name, and address, objects, limitation of liability, capital, types and classes of shares, subscribers.
We got that?
Can I slower?
She reading it from the notes. Go to notes,
The bottom.
but go to the legislation at the same time. Companies Act. Part 2. It starts off by saying constitution and incorporation of companies, legal formalities, method of incorporation. The first thing is you have to be of legal age. Sound mind. Not bankrupt.
Which one you looking at, the old version?
My old one, which I'm familiar with.
Yeah.
You say 2?
So you have to be.
Yeah, I can't read that thing.
18 years old.
Yeah.
No, that is an
Old
old one.
one, do they?
Oh, section 3, okay. 3.
Yeah, I just said part 2. On yours?
Yeah.
Yeah, should be in the same
Yeah.
area.
Oh, that's
Yeah.
not really, yeah.
Then subsection 4 says what? It tells you the liability of the members may be limited either to the amount, if any, unpaid on the shares relatively respectively held by them, or to such amount as the members may respectively undertake by the memorandum to contribute to the assets of the company in the event of its being wound up. And then it says in 5, where the company is incorporated on the principle of having the liability of its members limited to the amount unpaid on their shares, the memorandum shall state the name of the proposed company with the addition of the word limited or LTD, the location in the Bahamas of the registered office, the liability of each member is limited, the amount of capital with which the company proposes to be registered, its division into a stated number of shares of a certain fixed amount, that no subscriber may take less than 1 share, that each subscriber to the memorandum shall write opposite his name the number of shares he takes. That's what's in the memorandum. Then it said the number of shareholders, the amount of shares as indicated by the number of shares, the value of each share with which the company proposes to be registered. So that is if it is with limited liability. If it is unlimited, it says, where a company is formed on the principle of having no limit placed on the liability of its members, the memorandum shall state the name of the company, the location, where the company has a share capital that the liability is unlimited, and that each subscriber is obliged to write opposite his name the number of shares he takes and the number of members and the amount of share capital with which the company proposes to be registered. So when you write the memorandum, you can have it two ways. One, limited liability, one, unlimited liability. Then you can have it where the company is limited by guarantee. Because remember when we did the second class, we said it could be by shares or by guarantee. So where a company is formed on the principle of having their liability of its members limited to such amount as the members respectively undertake to contribute to the assets of the company in the event of a winding up, hereinafter referred to as a company limited by guarantee, the memorandum shall state limited or LTD, location, and the amount that each member intends to contribute towards the assets. Then section 8 speaks to a company that's limited by both shares and guarantee. Then 9 says the memorandum shall be signed by each subscriber in the presence of at least one witness who shall attest his signature. The memorandum shall, when registered, bind the company and the shareholders in the same extent as if each shareholder had subscribed his name and affixed his seal thereto. So when you go to incorporate the company and you prepare the memorandum, whoever's preparing it signs it. And they put your name there as the shareholder. And see, it says here, the memorandum shall, when registered, bind the company and the shareholders to the same extent as if each shareholder had subscribed his name and affixed his seal thereto. So he doesn't have to physically sign it. Once it's put there, the act says he's bound. There was contained in the memorandum on the part of himself, his heirs, executors, administrators, a covenant to observe all the conditions of such memorandum. So section 10 speaks to articles of association. But before we go to the articles, let's go to what a memorandum of association is under an IBC. So where's your IBC Act?
Can we backtrack?
Go ahead.
Somewhere I read that you could, normally you incorporate 5,000 shares or something like that, and then it's $100 for the 5,000, and then anything above that is more, correct? If I read it right. Does that mean, how does that 5,000 relate to the capital in the business? In terms of,
You could have a capital, but all of the shares don't have to be prescribed. You don't have to authorize all one time. You have to authorize shares and you have to issue shares. So you could authorize 5,000.
so when the company starts, there's 5,000 shares is what you're saying, but you don't have to issue those 5,000 shares to anybody.
No, you issue it to the first set of shareholders. So you have 5,000 shares, you can issue 3,000 or 2,000.
So then if you don't issue the other 2,000, who owns them then?
You do it over time. You don't have to do it all one time. You do it over time.
But then when the person comes in, when you give them shares, that is when you assign the value of how much you have to pay for the share or whatever the case might be. I don't understand how it works with the capital in relation to the shares.
Okay, so
I thought that when you say the company is limited liability due to shares, if there's 5,000 shares, that doesn't mean it's only capped at $5,000.
no, it's not. Depends on the price of the shares. You can issue shares at $1 each. You can issue it at $10 each. You issue it at $20 each.
So you could choose your own price you want to issue the
Mhm.
shares for then.
Yeah, because how much capital you wanna raise?
So piggybacking off what she was saying, so if I wanna issue a company with $5,000 worth of capital, and I'll just issue 5,000 shares at
About $1 each,
Par value of $1.
par value of $1. Mhm.
But why would I wanna change the price?
It depends on what you wanna raise.
But my
Just-
thing is, if a company only worth $5,000 and I sue the company and that's all their liability is at $5,000 and I sign a contract with them that exceeds $5,000, that's how come I don't understand how it quite works in
Yeah, but you're only
terms of-
looking at the capital
Yeah.
and not what's on the full balance sheet.
The authorized share
The
capital.
assets and the liabilities. You only get the authorized share capital when it's time to wind up.
Okay, so that doesn't come into play then if I
When you're
sue
doing
a
the daily
company.
operating, no, cause you gotta looking at how much funds do they have to pay you with.
The assets can exceed the capital, the
Mhm.
authorized share capital.
Yeah.
Okay.
And here, you can authorize the company up to 50,000 or over 50,000, there's no limit. If you, incorporating it under, if it's going to be, unlimited,
Then you just,
it can be any
Anything.
amount of shares.
But it does impact the fees that you pay for the company.
yes,
Okay, so that was what she was
Yeah.
asking.
Yeah.
She said, so when we, it's a $5,000 cap. She said for 5,000 you pay a certain amount.
yeah, the fees is a
And
different
then-
issue.
And then, okay,
It's different.
That's a different issue.
depending on how much, shares that were issued.
That's a different issue.
Okay.
So how do we incorporate a company under the IBC Act?
It's similar,
Mm-hmm.
the same requirements, you have to be of a mature age, 18 I believe. Have a sound mind and not bankrupt. That's what you incorporate.
So that is the same, what the next section says.
Some of the memo, okay, two or more persons, two subscribers are required.
Same as under the Companies Act.
As the Companies Act. And according to this, it's saying, subject to section 21B of the Financial Corporate Services Act, no person other than a bank, a trust company,
Mm-hmm.
licensed under the Banks and Trust Companies Regulation Act shall incorporate an international business company.
Unless such person is licensed and approved under the financial and corporate service.
So basically what they're trying to say is you have to
Mhm.
be, regulated under the Bank and Trust Companies
Mhm.
Act or the Financial Corporate Services Act in order to
In
open
order,
up a
you
IBC.
see, exactly.
But and other than that, you can open up a 1992 company.
Yes, a regular company.
Okay.
Now you're beginning to see the difference?
Yeah.
One
this
is
one's more
anyone can
regulated.
incorporate a company.
1992 company.
Right, what else it says?
It cannot be open to facilitate crime activity, criminal activity.
Mm-hmm.
And it cannot be open to facilitate any purpose that is against any of the Bahamian laws.
And that's what normally most of them, all companies in the Officers Clause, that's what it says. You can perform any business, but it cannot be anything that's criminal.
Yeah, anything illegal.
Then it says in section 6 that if you do engage in anything that's criminal, that it will be struck off. But you have 7 days to be heard. Then what it says about personal liability.
Once, no member, director, officer, agent, or liquidator of the company shall be liable for any debt, et cetera, once they acted in good faith. But they will be liable, they will have personal liability if it has been proven that they did not act in good faith.
So is it the same thing under the Companies Act?
I'm not sure.
Is a director liable?
Yes, they are liable, so I
But
think
if they
it's the
act in
same.
good faith?
No, hold on one second, I don't know.
They act in good faith, they're not.
They're not liable. As a director, as long as you act in good faith and in the best interest of the company, then you're not liable.
No, so that's for both sides.
It's both. And then a mode of limiting liability. It's the same as under the Companies Act. Then you could have a company limited by both shares and by guarantee. Then read 10, the powers.
I know we're skipping back, but I just have a question.
Go ahead.
For the IBC, we require 2 subscribers, the same thing is required for companies?
Mm-hmm.
Okay, I just wanted to make sure. So it's basically the same incorporation process up until this point,
Except who can incorporate.
except who can? Yes.
But
So
there's
the
a
difference is they have to be, regulated underneath the license under the Financial and Corporate Service Provider Act.
Or under the
Or the
banks and
bank and
trusts.
trust.
Yes,
But everything else in it's the same.
it's the same. We're just gonna,
I thought for companies you needed 2 and 2 or something, and then under the IBC Act it was 1.
Director.
one director. Cause remember I told you at the beginning, when we talk about types, that you'll have one shareholder, one director and an IBC, and he runs the whole thing himself. Versus a company, if you do it under the Companies Act, it's very rare, you will see a company with one shareholder and one director. You normally see that on an IBC because that's for international business by a non-resident. So let's go now to, so when you, in the memorandum, remember we asked at the very beginning of class, when she was talking about limited and LTD, the law has been amended whereby you can put limited, LTD, and all the other abbreviations that you can find in other companies act around the world. So it could be limited, LTD, LLC, corporation, corp, incorporated, Inc., GmbH, Sociedad Anónima, and they do that because you have companies that come here and they want to continue under the Bahamian legislation, but they don't want to change their names. So they have expanded it, so you'll have companies not with just company limited or LTD. They could have any one of these extensions at the end.
LLC, INC.
All in your notes on page 73. So under the IBC, what is required to be behind your name? Mm-hmm. Mhm. So they mirror the same extensions. Now notice it says here, no name should be incorporated under this act under name that is identical with that under which a company in existence is already incorporated. So that's why there's that whole incorporation process where you reserve the name, and then they have a certain number of days, and then if you don't incorporate the company, you can get an extension. And if any name is too close to the other name, then they just reject it. Or sometimes what some people do is they want a name so badly they wait until after the time period for whoever reserved the name has expired, and then they put in an application to take the name. Contains without express prior permission of the registrar, assurance, bank, building society, chamber of commerce, chartered, royal, trust. Why you think that provision is in there? Section 12, 3B. 3B. Why is that provision in there? That you need the prior permission of the registrar to include those words in the name of your company. Because they're regulated entities.
Which act are you looking at?
IBC.
That's an amendment. Oh, that's an
IBC.
amendment.
That's the IBC.
IBC.
Now I want you to go and see if it's in the Companies Act.
Section 12.
Section 12, 3B.
Yeah, it says
Mhm.
12, 1B in the Companies Act. It cannot contain assurance, bank, building society, chamber of commerce, charter, corporated, insurance, municipal, royal.
Right.
Or word conveying a similar meaning or any other word that in the opinion of the registrar suggests or is calculated to suggest the following. Patronage of the government of the Bahamas or minister of the government, connection of any ministry or department of the government, connection with any local authority or statutory board, or that is indecent or offensive in the opinion of the registrar.
Okay. But notice in the Companies Act, it says, both of them say the same thing. You cannot use a name that is indecent, offensive, or in the opinion of the registrar is otherwise objectionable. So it's identical. And it also says on the Companies Act, no nearly resembles the name of another company in existence which is already incorporated as to be calculated to deceive or confuse. So remember the issue we had with that restaurant whose name was similar to the one in the United States? Yeah. You cannot have a name that's so similar. That's why you have to be very careful. Because sometimes you may be reading a book, it may refer to a name of a place, and that name have already been used by an actual business, and then you can be sued. So you have to be very careful how you name your company, because it's not just here, but it's also internationally, it's worldwide.
So when they did that company here, they didn't have approval to get that name?
No,
From,
I mean here,
They
but it
got-
was an international name.
but they didn't get approval, they got approval here.
They may have, I'm sure they did,
So,
but they had a company with the exact name outside of the country.
But that was incorporated under the Companies Act or the IBC?
I wasn't sure which one it was, but both say the same thing. You can't deceive.
but was it, I mean, if it was different jurisdictions, would it have been deception?
Shouldn't it have been incorporated as a continuation and not?
It wasn't, they weren't two separate entities.
They just
had-
was separate,
Yeah,
okay.
but they only had one word, it's the same,
Mm-hmm.
it should not,
But I think that was an internationally known company.
maybe.
So
colors,
let's say
they
you
use
over-
the
so
same
you-
colors
Would have
and
been
everything.
obligated to franchise
From
fees,
Cat.
which is probably
Exactly.
what we're trying to
Uh-huh.
avoid.
Because they use the same colors.
So let's just say,
yeah.
let's just say we go now at Andres and we start selling hamburgers and we call it McDonald's Quick and Easy.
Okay.
You see what I mean? You're gonna be sued.
So why would they incorporate that company?
But if
Huh?
your name,
The which
if
one?
your name is McDonald's,
You mean if
The
they
who?
name, if they name
That's
the
Friday
company
start
first
to the
name?
restaurant Friday after next.
No.
What are you talking about?
No, there was another one.
That's not the one? That's not the one?
No.
Oh, I thought that's what you were talking about.
Mm-mm. There's more than one. So
Okay.
to be very careful
I
how
have
you
a
name your
question then.
companies.
So,
What?
see how they have, how you saying the McDonald's, how they have a McDonald's, the original McDonald's in the United States, and they have
Mhm.
franchises, and I come over and I name my restaurant, it's not a franchise, McDonald's, the same name.
We sold.
I could be sued, because the first, okay, now, on what grounds, does that?
Cause that is a franchise name.
No, I mean, if that original McDonald's, right,
Mm-hmm.
if that original McDonald's didn't copyright their name.
Oh, they
they
did,
still
they
s-
did.
No, I'm just saying, in the instance, so, I'm trying to figure out how do you avoid someone else using the name, you have, even though you've already incorporated in your jurisdiction, you have to copyright the name,
Mm-hmm.
in
But
order
that's
to sue them.
copyright is
Yeah.
worldwide then?
It's supposed to be.
Yeah.
Yeah. And they just amended the Patent Act and the Trademarks Act. Yeah. They just amended those two.
So just having the company isn't good enough, you have to
Mhm.
incorporate the name.
Copyright the name.
Let's say like a company like Palm Tree, they run a business. So would you be able to use that name?
It depends if it is still on the books.
Oh, okay. Okay.
So even if it's not on the books, you're okay to use it? If it's struck off?
If it's struck off.
Until you,
Struck off,
if
you
it's
can
struck
use
off, you
it.
can say the palm tree, but, or the new palm tree or something, cause people might still think.
They would still think it's the same one,
You're associated.
Oh.
cause it has a reputation.
Mm-hmm.
So that's why some people, when they do it, they'll say the new. If something was wrong with it, they'll say the new, so you don't use the same name. And people run out of names, cause they're using names of lizards and,
Wow. Yeah. 'cause
yeah, they're using
legislative
actual names,
laws.
like the actual scientific names of things, and putting it with a regular name in order to come up with a name, to avoid being sued. Okay, so let's look at the Articles of Association. Everybody knows what's in the memorandum now. You have that?
All the details of the company,
That ain't all.
not all the details, but
Shares.
the number of shares, number of authorized shares, the registered agent, registered office,
Mm-hmm.
Obviously the name of the company,
Its location.
its location.
Mm-hmm. All right, so now let's look at the articles. Mm-hmm. What's in the
On the
articles?
company or?
And the company,
We'll start with
that's
the companies
section-
first.
That's section 10 of the Companies Act. And it's signed by the subscribers to the memorandum. No, I'm sorry.
I want you to look at section 10, subsection 2. What does it say?
A company limited by shares may, instead of filing articles, notify the register in writing at the time of submission of its memorandum that it adopts the first schedule, either with or without modification.
Mm-hmm. I notice most companies, they actually still prepare memo and arts. And a lot of the companies like from Europe, they don't give you any memo and arts. Cause all they give you is the document to say they have selected the memo and arts on the first schedule, that's it. So every time you make a request for it, they will tell you, we don't have any. Cause what they've done is they've just adopted what's at the back. So go to the back and see if you see the first schedule. We have it?
Yeah.
Yeah.
Should be at the very back of your company's act.
That's it.
Yeah,
You're in there.
it's long.
There you go. So instead of having it all redone, you could just accept that as is.
Is this because they're online?
What?
Why do what he's doing?
Who's they?
Can you register?
Which act you just read?
Okay.
It's right here. But I'm saying here, we go through the long process of typing out all of this, right? But I'm saying the act says, you don't have to do that.
Okay.
You just adopt it, they have an
You could just, yeah, you just do rest of the I adopt before you schedule in the back, unless you wanna make some changes. You see what I mean? So you don't have to go and have all of this type out. And this is a lot, and that's why when they come, they're so thick. But if you just say you adopt the first schedule in the Companies Act, that's it.
A lot of people doing that too.
They're doing it now, right?
Yeah.
Because that's what they do in Europe.
The one little page and say.
It's one page. One page. So now let's go through the articles. This is the meat now. This is all the information. All right. So the purpose of these regulations, expressed, defined, don't worry about that. The directors shall have regard to the restrictions on the commencement of business imposed by section 42 of the Act if and so far as those restrictions are relevant to the company. So what does section 42 say?
Okay, let me go down.
That a company shall not commence business or exercise any borrowing power unless shares held subject to the payment of the whole amount thereof in cash have been allotted to an amount not less in the whole than the minimum subscription. Every director of the company has paid to the company on each of the shares taken or contracted to be taken by him and for which he is liable to pay in cash a proportion equal to the proportion payable on application and allotment of the shares offered for public subscription. And there has been filed with the registrar a statutory declaration by the secretary or one of the directors in the approved form that the conditions specified in section 40 have been complied with.
There's been filed with the registrar statutory declaration by the secretary or one of the directors in the approved form that the conditions specified in section 40, and section 40 speaks to restrictions as to the allotment in terms of capital, share capital of the company. In the case of a company which does not issue prospectus inviting the public to subscribe for its shares, there has been delivered to the registrar a statement in lieu of prospectus. What kind of company are they talking about? What is that restriction? What is the restriction on?
Not a private company.
It's a public company.
Christy, where you just read from?
The Act, Companies Act,
42.
section 42 and section 40. Cause 42 then sends you to 40.
That's in the old act.
What in the new act? No, she has the new act. Same sections, eh? Okay.
Okay, could you explain that again? The section 5,
You
The
get
first-
5.
no,
No, she-
item 5, number 5 of the first schedule where it's saying no share shall be offered to the public.
Read it, yeah?
I thought that's what you were
We
doing.
here. Right here.
Oh, I jumped ahead of you.
Yeah.
Sorry about that, I got confused.
Yeah, we're right here.
We talking about section 2. We talking about
Section
number
2.
2, right?
Yeah.
Okay.
No, I was.
So now we go into shares. It says, subject to the provisions, if any, in that behalf of the memorandum of the company, and without prejudice to any special rights previously conferred on the holders of existing shares in the company, any share in the company may be issued with such preferred, deferred, or other special rights or such restrictions. So here, it just tells you.
This is in the schedule?
Right there. So it tells you can issue your shares in different categories. And you don't have to do it all at the very beginning. As you move further, like how Commonwealth Bank did theirs, you just have common shares, then you get have preferred shares, different classes of shares as you operate the company. 4 says, where at any time the share capital is divided into different classes of shares, the rights attached to any class may be varied by a resolution of directors. And when you read the articles, it actually tells you what actions require a resolution. No share shall be offered to the public for subscription except upon the terms that the amount payable on application shall be at least 5% of the nominal amount of the share, and the director shall, as regards any allotment of shares, duly comply with such of the provisions of sections 40 to 42. So you're talking about when you do an IPO. Every person whose name is entered as a member in the register of members shall, without payment, be entitled to a certificate under the common seal of the company specifying the share. What are they telling you? No, what are they telling you? The share certificate. And the seal has to be on it. So anyone who said that they're a shareholder of a company should have a share certificate with the seal on it. If it's misplaced, no, they'll issue a new one, but they'll do it by resolution. It says, what else says?
But that would apply for the public companies, for everyone who has a share in it, who has purchased shares, like if they go through CFAL or the 6, or not them. Okay.
A share certificate defaced, lost, or destroyed may be renewed on payment of such fee, if any, as may be prescribed, and on such terms of any as to evidence and indemnity as the directors think fit. So they leave that one open. No part of the funds of the company shall be employed in the purchase of or in loans upon the security of the company's shares. So it limits you right there. You see what it says?
So if you wanna buy additional shares, you have to pay.
You have to bring fresh money in.
Yeah, okay.
9, lien. The company shall have a lien on every share, not being fully paid up for all monies, called or payable at a fixed time in respect of that share. You know, sometimes when you have companies and say they're calling back shares. Okay. The company shall have a lien on all shares standing registered in the name of a single person for all monies presently payable by him or his estate to the company, but the directors may at any time declare any share to be wholly or in part exempt from the provisions of this clause. So that gives the company the right to call back the shares. 10, the company may sell in any such manner as the directors think fit any shares on which the company has a lien, but no sale shall be made unless some sum in respect of which the lien exists is presently payable, nor until the expiration of 14 days after notice in writing, stating and demanding payment of such part of the amount in respect of which the lien exists as is presently payable. 11, the proceeds of the sale should be applied in payment of such part of the amount in respect of which the lien exists as is presently payable. 12, the joint holders of a share shall be jointly and severally liable to payable all calls in respect thereof. And whereas some called in respect of a share is not paid before or on the day appointed for payment, the person for whom the sum is due shall pay interest upon the sum. So all this is doing is the regularization where the bank has a lien and does a callback, what it can charge and what it can do. Then the next section speaks to 17, transfer and transmission of shares. The instrument of transfer of any shares in the company shall be executed both by the transferor and the transferee. Remember, whenever someone say they have a share and they want to transfer it, and people always ask, what's the process? Like, what should we do? The instructions are right in the articles. Shares in the company shall be transferred in the following form or in any unusual or common form for which directors shall approve. So if they're not going to follow this, then in their actual memo, they will state what the form is. If it is silent, then they will come right here and use this.
And so if the company has not adopted this one, these same categories that are in this would be in the articles.
Not necessarily.
So they don't have to speak on some of these items.
No, but if you don't speak to it, what happens? You go right back here to the act.
Okay.
Shares in the company should be transferred in the following form, and then they give you an example how it can be worded. In consideration of the sum of money paid to me by, and you know the words in consideration, what that means? In consideration.
The consideration is whatever was exchanged.
Right. So when you say in consideration, consideration is the third element to form the contract,
Yeah.
because that's the exchange of the money.
Exchange of whatever they do.
Mhm. So you're already in a contractual arrangement once you exchange that money. In consideration of the sum paid to me by whoever, do hereby transfer to the said transferee the shares numbered and so and so. So sometimes it's at the back of the certificate, and then sometimes they actually drop the document. The directors may decline to register any transfer of shares, not being fully paid up shares, to a person whom they do not approve, and they may also decline to register any transfer of shares on which the company has a lien. The directors may also suspend the registration of transfers during the 14 days immediately preceding the ordinary general meeting each year. They may decline to recognize any instrument of transfer unless the fees are paid and the instrument of transfer is accompanied by a certificate of the shares to which it relates. So it actually gives you the whole process. If you want a transfer, you actually fill out the document and say, I'm transferring my shares to you. You have to have the cash to pay for it. And then it also says here that my original certificate has to be attached to it. The executors or administrators of a deceased sole holder of a share should be the only person recognized by the company as having any title to the share. What does that mean?
Once the person who would have owned the shares died, whoever is their
Executor or administrator is the only person the company will recognize or take instructions from. Yeah. In the case of a share registered in the names of two or more holders, the survivor or the executor or administrator of the deceased survivor should be the only person recognized by the company as having any title to the share. So let's just say she and I own the share jointly. They're telling you she cannot come and speak on my behalf, the deceased. It still has to be the executor or administrator of the deceased. Hold on. Or you got that? Okay. If she and I own the share jointly, so the share certificate has my name and her name, and I'm deceased, she cannot come and speak on my behalf. She cannot do the transfer. It has to be the executor or the administrator.
so it's still jointly, but with
Even
the
if it's joint,
executor.
even if it's joint.
If that's what it says.
The
Mhm.
executor speaks not the person who joined.
20, Article 20. It says in the case of a share registered names of two or more holders, the survivors, or executors or administrator of deceased survivor should be the only persons recognized by the company as having any title to the share. So the survivors, yeah, she can, yeah.
If it's one person.
Right, she can.
Okay.
Any person being entitled to a share in consequence of the death or bankruptcy of a member shall, upon such evidence being produced, having the right either to be registered as a member in respect of the share, or instead of being registered himself, make such transfer of the share as the deceased or bankrupt person could have made. But the director shall in either case have the same right to decline or suspend registration. So even though if you write a will and I transfer my shares to you, the directors can still decline. They have the right to decline.
By law, it could, the joint shareholder.
No, this ain't joint now. This is just
Shareholder, sole shareholder.
I stipulate that.
no.
That's sole
No.
shareholder,
Any person being entitled to a share in consequence of death or bankruptcy.
Okay.
So say in the will, I say I leave my share to you. They're telling you here that directors still have the same right to decline, to suspend, to reject it. They can say I don't want you as a shareholder. They have that right.
Okay.
Alright, they still have a
But
right to say this right here.
In bankruptcy though, that would mean they have to pay out the share to the, court appointed person
Mhm,
who's
yeah.
liquidated the
Mhm.
estate then, if they say they can't hold the shares.
Yeah. A person being entitled to a share by reason of the death or bankruptcy of the holder shall be entitled to the same dividends and other advantages to which he would be entitled if he were the registered holder of the share, except that he shall not, before register as a member in respect of the share, be entitled in respect of it to exercise any right conferred by membership in relation to meetings of the company. You get that?
He
You-
get the
you
benefits,
get-
but he don't have no voting.
He has no voting rights.
No voting rights.
He has to wait until he's registered as a member. So the person died, they left you to share in the company, right? You can get the dividends, but until you're actually registered on the company's books, you have no say. Okay, 23. Where a member fails to pay any call or installment of a call on the day appointed for payment thereof, the directors may at any time thereafter, during such time as any part of such call or installment remains unpaid, serve a notice on him requiring payment of so much of the call or installment as is unpaid, together with any interest which may have accrued. The notice shall name a further date when he has to pay. A forfeiture share may be sold or otherwise disposed of on any such terms and in such manners as the directors think fit. At any time before a sale or disposition, the forfeiture may be cancelled on such terms as the director may think fit. A person whose shares are being forfeited should cease to be a member in respect of the forfeited shares, but shall remain liable to pay to the company all monies which, at the date of the forfeiture, was payable by him. So even though they forfeit your shares, whatever you owe the company, you have to pay. Then you could have conversion of shares into stock, that's section 30 to 31. The directors may, with the approval of the company previously given in general meeting, convert any paid up shares into stock, and may, with the like approval, reconvert any stock into paid up shares of any denomination. Then you have share warrants.
27, no, that isn't fair. Because if I still have to pay you for the shares, even though I forfeited, I should still be able to get the benefit of the shares because you still benefit and you've taken the shares. You could sell the shares to someone else, but yet you saying I still have to pay you for those shares.
Mm-hmm.
That's you being enriched twice.
Mm-hmm. So if you don't like that clause you form in your company, then you have to write your own. You see what I mean? Because this is the standard. This is the standard. That's what you agree to.
I want go 20 when we were talking about it. It's saying in fact that two persons own the shares, two persons name on the shares, and that one person deceased. If that basically they don't have the right, the second person do not have
Yes,
the
they
right.
do.
If you
Yeah,
want the
they
right,
do.
the survivor's
This is
order.
survivor's
The
or.
survivor order,
Okay.
Or.
executive order administration, whoever they need in charge of the deceased.
But is it like in land where two people own the property jointly and the other one died, the other one gets the whole?
It depends.
Yeah, but in there it just says joint aid for the shares.
No, it just says two or more holders. That's it. Doesn't say jointly. It says two or more holders. They're just holders. So I guess if two, so that means that if you and I wanted to own shares in a company together, we should have an underlying document stating whether or not we're holding it jointly or as tenants in common. Because that's how it is normally when you purchase registered stock. The wording of it tells whether or not you're holding it jointly or as tenants in common. Alteration of capital. The company may, by resolution of shareholders, increase the share capital by such sum to be divided into shares. Section 40. All new shares shall before issue be offered to such persons as at the date of the offer are entitled to receive notices from the company of general meetings in proportion as nearly as circumstances admit. The offer shall be made by notice specifying the number of shares offered and limiting a time. The directors may likewise so dispose of any new shares which cannot, in the opinion of the directors, be conveniently offered under this article. And then that's new shares. General meetings. The statutory general meeting of the company shall be held within the period required by section 70 of the Companies Act.
65, yeah.
How you get, oh, because we have different number. So we're just 65, say, because I have 70.
Yeah, let's say 65.
I have 65 too.
It says,
Well, you know mine will work.
I have the old one too.
it says the instrument appointing a proxy and the power of attorney or other authority, if any, under which it is signed or certified copy of that power of authority shall be deposited at the registered office of the company not less than 48 hours before the holding of the meeting at which the person named in the instrument proposes to vote, and in default the instrument of proxy shall not be treated as valid.
That's what your section 70 say?
65.
65.
Oh, you're 65.
Oh,
That's what, no, that's what my,
no.
section
I
70?
read, I should read 65 of the act.
Yeah, of the act, okay. So mine is 70. Say subject,
65.
right, subject to subsection 2, a general meeting of every company incorporated under this act shall be held at least every year.
Yeah. Mhm.
Where
But
are you?
65
Where are
says
you?
it.
65.
65
don't
says
say
that.
that.
65 says it's Christine.
65.
65 of the
Oh, I in
company
the
act.
IBC.
You in IBC.
65 says it for us.
Okay,
Subject to subsection 2.
right. So every company limited by shares and every company limited by guarantee and having a share capital shall, within 3 months from the date of incorporation, hold a general meeting of the members of the company, which should be called the statutory meeting.
Yes.
You remember I said that's one of the disadvantages of forming a company, because you have to stick to these times.
So you have to so how would the registrar of companies do? You have to send this information to registrar?
Yeah, yeah.
Oh, okay.
So you know the date you incorporated,
Mhm.
3 months after you have to have it.
They have, they
Yes,
have to send it,
yeah,
but
so that's what the law requires.
Okay.
Any such meeting shall be called by the directors of the company, and then, hold on, don't do that one next. Let's go back to a general meeting shall be held once at such time, not being more than 15 months after the holding of the last previous general meeting, and place as may be prescribed by the company in general meeting or in default. In default of a general meeting being so held, a general meeting shall be held in the month next following and may be convened by any 2 members in the same manner as nearly as possible. The above mentioned general meetings shall be called ordinary meetings, and all other meetings shall be called extraordinary meetings. So you see people normally use these terms, they say special meeting, ordinary meeting, extraordinary meetings. Okay.
So the AGM is the ordinary meeting, and extraordinary be anything other than that.
What's the AGM?
I mean,
Annual general meeting.
Uh,
Then you have what? Extraordinary meetings. What section 71 says?
Section 66.
You mean 66 for you? Mm-hmm.
Notwithstanding anything contained in the articles, the directors of the company shall, on the requisition of members of the company, holding at the date of deposit of the requisition, not less than 1/10 of the paid-up capital of the company which, as at the date of the deposit, carries the right of voting at general meetings of the company. Or in the case of the company not having a share capital, members of the company representing not less than 1/10 of the total voting rights of all the members, having at the date of the deposit of the requisition a right to vote at general meetings of the company, immediately proceed duly duly to convene an extraordinary general meeting of the company.
Okay, so go to section 48. In the articles, it says 7 days notice at the least, specifying the place, the day, and the hour of meeting, and in case of special business, the general nature of that business shall be given in the manner hereinafter mentioned or in such other manner. Now, even though they say 7 days notice, it depends on the agenda. If the agenda is really detailed with a lot of information, some people ask for at least 2 weeks, 3 weeks notice in order to be able to read all the items on the agenda. All business shall be deemed special that is transacted at an extraordinary meeting, and all that is transacted at an ordinary meeting, with the exception of sanctioning a dividend, the consideration of the accounts, balance sheets, and the ordinary report of the directors and auditors, election of directors and other officers in the place of those retiring by rotation, and the fixing of the remuneration of the auditors. What does that mean?
It seems like
49.
2 meetings in one almost.
Yes, they do. They do 2 meetings in one.
is the ordinary ones and one is true.
They do the 2 one time. One is a meeting within a meeting. So within the meeting, they would sanction the dividend, consider the accounts, appoint the directors, appoint the auditors, and elect the new officers or signatories within the meeting. And then they go back to the regular meeting. No business shall be transacted at any general meeting unless a quorum of members is present at the time when the meeting proceeds to business, save as herein otherwise provided. 3 members personally present shall be a quorum.
2 members.
I have 3.
2 members.
Two members.
You have 2?
Well, two.
Okay.
I have two.
Did you have 2?
Two.
Well, I have 3. Well, I know mine over.
Do you want me to print this for you?
Yeah, to look like that, because what he sent me, I cannot read. We are within half an hour from the time appointed for the meeting. A quorum is not present. The meeting, if you have 3 too, if convened upon the requisition of members, shall be dissolved, and in any other case, it shall stand adjourned to the day in the next week at the same place and time. And where the adjourned meeting a quorum is not present, within half an hour from the time appointed for the meeting, the members present shall be a quorum. You see that is? You can have a meeting, you don't have a quorum. You can adjourn, and if you have the same amount again, you have the meeting.
Yeah,
So if there's less, you count that?
yeah, the second time.
Yeah, the second time around, it's the same amount, you have a quorum. If it's less, you can't. The chairman, if any, of the board of directors shall preside as chairman at every general meeting of the company. Now they say the chairman, if any, because sometimes if the chairman is not present, then he may actually ask another director to chair the meeting. Where there is no such chairman at any meeting, he is not present within 15 minutes from the time appointed for holding the meeting, or is unwilling to act as chairman, the members present shall choose someone of their number to be chairman, so the meeting doesn't stop. No. The chairman may, with the consent of any meeting at which a quorum is present, adjourn the meeting from time to time, from place to place. But no business shall be transacted at any adjourned meeting other than the business left unfinished at the meeting from which the adjournment took place. So all the rules for corporate secretary and how the board should be run is right here in the articles. Because you know, a lot of people say when you're appointed as a secretary, what do you do? How do I know what to do? All instructions are right here. When a meeting is adjourned for 10 days or more, notice of the adjourned meeting shall be given as in the case of an original meeting. So you write a whole new agenda and send out new notice and everything again. This they say of us officers, it shall not be necessary to give any notice of an adjournment or of the business to be transacted at an adjourned meeting. At a general meeting, a resolution put to the vote of the meeting shall be decided on a show of hands unless a poll is demanded by at least 3 members unless a poll is so demanded, a declaration by the chairman that a resolution has, on the show of hands, been carried or carried unanimously or by a particular majority or loss, and an entry to that effect in the book of the proceedings of the meeting of the company shall be conclusive evidence of the fact, without proof of the number or proportion of the votes. What does that mean?
So you just say whether it was by, even though you don't do a show of hands or whatever,
Mm-hmm.
you just, whatever number, whatever majority wins or lose, you just record that, but you don't say by how many numbers.
No, you just say by resolution,
Oh,
the company hereby approves the purchase of this laptop. That's it. If a poll is duly demanded, it shall be taken in such manner as the chairman directs, and the result of the poll shall be deemed to be the resolution of the meeting at which the poll was demanded. In the case of an equality of votes, whether on a show of hands or on a poll, the chairman of the meeting at which the show of hands takes place or at which the poll is demanded shall be entitled to a second or casting vote. So normally the chairman would say, who moves the motion? Who seconds the motion? Carry the motion. Done. So if the rest of them be quiet, it's done. Because when he has enough, that's it. Votes. On a show of hand, every member present in person shall have one vote. On a poll, every member shall have one vote for each share of which he is the holder. In the case of joint holders, the vote of the senior who tenders a vote, whether in person or by proxy, shall be accepted to the exclusion of the votes of the other joint holders. A member of unsound mind, or in respect of whom an order has been made by any court having jurisdiction with respect to persons of unsound mind, may vote whether on a show of hands or on poll. Because you know, normally when they say people with unsound mind, they can't do certain things by law. But it says here, a member of unsound mind may vote whether on a show of hands or on poll by his committee or any other person in the nature of a committee appointed by that court, and any such committee or person may, on a poll, vote by proxy. No member shall be entitled to vote at any general meeting unless all calls or other sums presently payable by him in respect of shares in the company have been paid.
so when they talk about that one with the sound mind, somebody was acting on his behalf?
Yeah,
Okay.
by proxy. So does not just because he has unsound mind means that he cannot exercise his right to vote. He can have someone do it on his
So-
behalf.
The poll vote is where you write it on paper.
Mhm. Or the proxy is where they have the form, and you just authorize someone else to do it for you. No person shall act as proxy unless either he is entitled on his own behalf to be present and vote at the meeting at which he acts as proxy, or he has been appointed to act at the meeting as proxy for a corporation. So there's two ways you could do it. And then they give you an example of what a proxy, how it can be worded in section 66. The number of directors and the names of the first director shall be determined in writing by the subscribers of the memorandum. So that's when you incorporate. Now the powers and duties. The business of the company shall be managed by directors who may pay all expenses incurred in getting up and registering the company, and may exercise all such powers of the company as are not by the Companies Act or by these articles required to be exercised by the company in general meeting. The directors may from time to time appoint one or more of their body to the office of managing director or manager for such time or such remuneration as they may think fit. And a director so appointed shall not, while holding that office, be subject to retirement by rotation or taken into account in determining the rotation of retirement of directors. But his appointment shall be subject to determination ipso facto if he ceases from any cause to be director of the company in general meeting resolved. That is, tenure of the office of managing director or manager be determined. So that is why normally you see the managing director is also a director on the board, because he's normally appointed from among the directors. The amount for the time being remaining undischarged of monies borrowed or raised by the directors for the purposes of the company shall not at any time exceed the issued capital of the company without sanction of the company in general meeting. The director should duly comply with the Companies Act, and in particular with provisions in regard to the registration of the particulars of mortgages and charges affecting the property of the company. What I'm telling you. Section 71. '71 and 72. It places directly on the directors this responsibility, their duties. Because it's not just you come to the meeting, you voting, and then you get paid and leave. You see what it says? They have to comply with the Companies Act. They have to make sure that if there are any mortgages and charges against the company, that they're actually registered. And that the annual list of members is actually sent to the registrar. Any consolidation, share capital conversion, the resolutions, all of that, they have to be aware that these things are actually done. And 72 says what? They to make sure that the minutes are done. Of all appointments of officers made by the directors, the names of the directors, of all resolutions and proceedings at all meetings. So even though you are direct, you sit at the meeting, you hear them call for a motion, you agree, next meeting you get the minutes again. But you have a responsibility to ensure that the corporate secretary has prepared the resolutions for all of them in the resolution binder. So you have the minutes binder and then you have the resolutions binder. So it's two different binders. The seal. The seal of the company shall not be affixed to any instrument except by the authority of a resolution of the directors, and in the presence of at least 2 directors and of the secretary or such other person as the directors may appoint for the purpose. And those 2 directors and secretary or other person, as aforesaid, shall sign every instrument to which the seal of the company is so affixed in their presence. So we go back to the question that she asked. Remember I told you to go and look in the memo and ask, what did it say? You didn't look at it. Because remember, it'll tell you when you can actually use the seal. So it says here, shall not be affixed to any instrument except by the authority of a resolution of the directors. So the directors, when you pass the motion, and they will say at the end that this agreement will be sealed by the company. Then you put the seal on it. That's why you see most times when you ask for a document and you say, well, I want a company seal, and they tell you, well, we don't put seal on those. And you keep saying, well, why? They don't seal every document. Now, if it's a document that requires a resolution by the board, then you will see it being sealed. Rotation of directors. At the first ordinary meeting of the company, all directors shall retire from office at ordinary meeting every subsequent year. 1/3 of the directors for the time being, or if their number is not 3 or a multiple of 3, then the nearest numbers to 1/3. But you have 3 or 2?
3.
Oh, you got 3 this time, eh? Because remember, every year they elect the officers. The directors to retire in every year shall be those who have been longest in office since their last election. But as between persons who become directors on the same day, those to retire shall be determined by lot. Understand what that means? It was here draw straws. A retiring director shall be eligible for re-election. The company at the general meeting at which a director retires in the manner aforesaid may fill the vacant office by electing a person thereto. Where any meeting at which an election of officers ought to take place, the placing of the vacating directors are not filled, the meeting shall stand adjourned till the same day in the next week at the same place, same time. And if the adjourned meeting and the places of the vacating directors are not filled, the vacating directors or such of them as have not had their places filled shall deem to have been re-elected at the adjourned meeting. The company may from time to time in general meeting increase or reduce the number of directors and may also determine in what rotation the increase or reduced number is to go out of office. And remember, the ceiling for the number of directors is set in the shareholders agreement. The director shall have power at any time and from time to time to appoint a person as an additional director who shall retire from office at the next following ordinary meeting, but shall be eligible for election by the company at that meeting as an additional director. The company may by resolution remove any director, appoint another director in place of the director being removed. So you see what I said what the article does? It tells you when a resolution is required. It tells you when a seal is required. All your instructions are in here. If you are a secretary, it tells you when to send notice, when there is a quorum, who should be present, how many should be present, the role of the chairman, minutes to be taken, resolutions to be written. All of that is right in here.
Cause I had a second look at the legal opinion that we got back from the attorneys and they did say, that the receiver in that case did not have to use the seal and keep an article.
Yeah. Yeah. So you could just go and look again in the articles and you'll see they may have just adopted this, something similar just like this, the same schedule, and if that's what it says, then you can't use it. But it's so amazing that people who run a company believe you run a company like how you run a tuck shop. You see what I'm saying? There are rules, and the rules are in these same 2 documents. They tell you what you can do, and when it is silent, then you go to the actual act.
So where there's reference of the director in the articles, that would apply to the receiver, because the receiver's acting as the director.
Director. The directors, 83, the directors may meet together for the dispatch of business, adjourn and otherwise regulate their meetings as they think fit. Questions arising in any meeting shall be decided by a majority. A director may, and the secretary, on the requisition of a director, shall at any time summon a meeting of the directors. So it don't actually have to be a meeting every quarter. The quorum necessary for the transaction of the business of the directors may be fixed by the directors, and unless so fixed, shall be 3. The continuing directors may act, notwithstanding any vacancy in their body, but if and so long as their number is reduced below the number fixed by or pursuant to the regulations of the company as a necessary quorum of directors, the continuing directors may act for the purpose of increasing the number of directors so that number or of summoning a general meeting of the company, but for no other purpose. The directors may elect a chairman of their meeting and determine the period for which he is to hold office. But if no such chairman is elected, or if at any meeting the chairman is not present within 5 minutes after the time appointed for holding the same, the directors may choose one among them. The directors may delegate any of their powers to committees consisting of such members or members of their body as they think fit. Any committee so formed shall, in the exercise of the power so delegated, conform to any regulations that may be imposed on them by the directors. So at 87, when a director says he's delegating his duties to management, if he's going to form a committee, if the board says we want to form an audit committee or compensation committee, when they say that committee, because it is board appointed, must have a mandate that is approved by the board. And a member of the board, one of the directors, sit on that committee. Because when they sit on that committee, they represent the board. And so normally, when you select directors, you select directors based upon their skills and their experience and what value they can add to the company. So that when you form committees, you select one of them to sit on the board or on that committee to bring back what you're looking for. So what else they say? Dividends. The directors may from time to time pay to the members such interim dividends as appear to the directors to be justified by the profits of the company. No dividend shall be paid otherwise than out of profits, subject to the rights of persons, if any, entitled to shares, with special rights as to dividends. All dividends shall be declared and paid according to the amounts paid up on the shares. But if and so long as nothing is paid up, or any of the shares in the company, dividends may be declared and paid according to the amounts of the shares. No amount paid up on a share in advance of call shall, while carrying interest, be treated for the purpose of this article as paid up on the shares. Where several persons are registered as joint holders of any share,
Sorry, I don't understand that last line. No amount paid up on share in advance of calls shall, while carrying interest be treated.
remember there's a callback.
That
The one
makes
you
it a
didn't
million,
like.
right?
So that if they call the shares back and then you go in and pay something, that doesn't count, that is what they're saying.
Yeah, no amount paid up on a share in advance of call shall be treated for the purpose of this article as paid up on the
But in
shares.
advance of call, if you already paid it before the call, that just don't,
But it already called.
they said
No
in
amount paid up on a
advance.
share in advance of calls shall, while carrying interest. That mean you're behind. Cause you're carrying interest.
Yeah, but how do you know? Okay. How do you know when they're gonna call it then? Even if you behind and you go in to pay to bring it up to date. They're saying that no share amount paid up on a share in advance of call while carrying street versus.
As a paid up,
As
it's
paid
just,
up.
yeah, it's not treated as, because it's not paid up.
I know they have, and sometimes they have like a declaration
that's a
date, like they
contradiction.
would pay
If I go in to
dividends
pay it-
as of, like persons who
You
might have the
understand what I'm saying?
shares
If I
or
go
up to like a certain point.
Mm-hmm.
So I mean, maybe that would fall within that category.
Yeah, I thought.
They
Cause
basically
I normally
just
give you the
trying to
date.
say
Mm-hmm.
that if it isn't paid up prior to the call back, it wouldn't be considered paid.
Mm-hmm.
That's all, I
Right.
mean,
Yeah,
it-
but
I
she-
mean,
But they
it's kinda
said
like a
in
double
advance
standard.
of the call. So if you saying it's carrying interest yesterday,
Yeah,
and
but
I
don't
go
forget-
to pay all the money yesterday to get rid of the interest that's owed
But you
and
get
all
notice of
that.
the call.
Mm-hmm.
So
Okay,
you get
just
notice
don't say
today to
that.
say the call is
As
on
of a
this
certain
day,
day.
as
So
of this
if I
day.
go to pay before that call, it
It-
is not
it-
considered paid up, it has to
exactly.
be prior to the notice.
But that's after the notice.
No, that'd be prior to the notice.
Prior to the notice.
If I pay it prior to the notice, shouldn't
When,
it
okay,
be?
when the notice comes, the notice is gonna say, call is going to be on the 27th of October.
Okay. So once the notice come out, it don't matter what I pay.
No.
Okay, now that makes more
Okay.
sense.
No dividend shall bear interest against the company. There's a man who comes all the time to the bank on Bay Street. He used to go to every bank. So he bought some shares.
No, we mean,
I don't know, is it? No, not him, no. This is a man, he had a company, he walks with a stick now. And he always be saying they owe him interest on it.
He used to,
That's on, but curly hair?
curly hair.
No, not him. I know who you mean, not him. No, there's another man. He had little sharp features.
He's old,
Yeah.
always talking a day old,
Yes.
always.
Him. He keeps saying, yeah, that he has shares. Yeah, go ahead. He keeps saying he has shares and they owe him interest.
And he walks wherever he have to.
Wherever he has to go, he
He
walks.
he don't catch.
And they say they say he is kind of,
They
he's
say
wealthy.
They say he has some money, but I don't understand how you can have all
They
this
say
money
he's
and not
wealthy,
have
but he
to
keeps
do
saying that he has shares and all of these different companies, but they owe him interest.
He used to do bombing back in the day, that's what they said.
Yeah, and he invested his money. So he said all he has now is just the shares, but he has no interest.
And when I saw him, I didn't know he was on a king, cause he said that he had an accident.
Yes, he has a, yeah, you're talking about the same man.
With the same person.
Mm-hmm. Yeah.
Everybody. He always say everybody.
Mm-hmm. Cause he's normally be the one, he'll be on Bay Street and he'll be advising people to buy registered stock
He been saying that.
and invest in BISX. So he probably is an investor. They say he has money, but he keeps saying is that he's not being paid any interest on his shares. You may miss him now because he walks with a stick. So it says no dividend shall bear interest against the company, and I think that's what his argument is.
Do they sell drinks or something?
Downstairs. Accounts. The director shall cause true accounts to be kept. Remember Enron? You see what it says? Directors shall cause true accounts to be kept. So you can't sit there and not ask questions. You have to ask questions. And remember now, you have the information prior to coming to. So you have enough time to do research to see if 1 and 1 is 2 or 1 and 1 is 5. What you making for now, Candy?
Yes.
Yeah, you want it?
No, go ahead.
The sum of all monies received and expended by the company and a matter in respect of which such receipt and expenditure takes place, and of the assets and the liabilities. The book of accounts should be kept at the registered office of the company or at such other place as the directors think fit, and shall always be open to the inspection of the directors. They have the right to see the book of accounts. The directors from time to time determine whether and to what extent and at what times and places and under what conditions or regulations the accounts and books of the company or any of them shall be open to the inspection of members not being directors and no member, and shall have any right of inspecting any book, account or book or document of the company except as conferred by statute. Once at least in every year the director shall lay before the company in general meeting a profit and loss account for the period since the preceding account, since the incorporation of the company made up to a date not more than 6 months before such meeting. A balance sheet shall be made out in every year and laid before the company. So what this is telling you, at the year end, they have to present profit and loss and the balance sheet. It's required. The balance sheet should be accompanied by a report of the directors as to the state of the company's affairs and the amount which they recommend to be paid by way of dividend, and the amount, if any, which they propose to carry to a reserve fund. So that means that when you make a profit, all of it cannot be paid out as dividend. A copy of the balance sheet and report shall, 7 days previous to the meeting, be sent to the persons entitled to receive notices of general meeting in a manner in which notices are to be given hereunder. And then it tells you notices. A notice may be given by the company to any member, either personally or sending it by post to him to his registered address, or if he has no registered address in the Bahamas, to the address, if any, within the Bahamas supplied by him to the company for the giving of notices to him. You see what it says? If he has no registered address in the Bahamas, to the address, if any, within the Bahamas supplied by him to the company for the giving of notices to him. So it doesn't speak to if you have to contact them outside the jurisdiction. No. So I guess in some instances, let's see, hold on. Where a member has no registered address in the Bahamas and has not supplied to the company an address within the Bahamas for the giving of notices to him, a notice addressed to him and advertised in a newspaper circulating in the neighborhood of the registered office of the company, that most definitely you have to change. Can't have that in a regular one, no. Where notice is sent by post, don't send it from here. Service of the notice shall be deemed to be effected by properly addressing, prepaying, and posting a letter containing the notice. Now this section needs to be changed in this modern day. A notice may be given by the company to the joint holders of a share by giving a notice to the joint holder named first in the register in respect of the share. So it's in both of our names, and they'll send it to me. Well, you better pray when I deposit it account, I let you know. Because I may just be taking all. Let me see, where's that thing in here? Alright, so when you go to your capstone, talking about where I said making any, research, any changes, that's one area you can look at in other jurisdictions. Under the Articles of Association, notices 105. See what other countries are doing. Go to your capstone, right, say you do the research, yes. So you see this is an area that you can look into. Hmm? You see it? Yeah. I need to do some research, give you that section. So when you answer in your capstone things on notice of meetings, adjournment of meetings, quorum of meetings, where do you find your source information? In articles?
So I have a question, if you
Go ahead.
just wanna let's say you, this article, right?
Mm-hmm.
And you have one item you wanna change, you would have to produce a new article?
Yeah.
Oh,
Yeah, cause when you adopt that as is.
oh, okay,
Yeah.
that's it, okay.
Yeah, as is. So whatever you want to change,
Mhm.
you'll have to write a whole new one.
Okay.
But like I say, in most instances, in other jurisdictions, they have amended it because their articles are no more than 3 or 4 pages. They don't have all of that long stuff. I don't know how to do it. Alright, so go on your page 75 in your notes. The main constitutive documents and instruments for a company's act companies. You just did the memo and articles. You know we get the certificate of incorporation from the registrar. We already know we have to do the share certificate book and the share transfer forms. Corporate seal. Then you need a nameplate. Register. What do you mean, what it is? The plate outside.
Oh,
The name of
okay.
the company. Yeah,
Oh,
yeah.
okay.
Why you need that?
Show them where your office is, that's the registered office and location.
Everything goes by law. Go on the Companies Act. Go in the Companies Act. What does it say? Yeah. Go to the act. What does it say?
It's a publication of the.
What it says? Use your fancy one. Hmm? It's required by law to have your name displayed, you know.
Yeah.
Found the section?
Yes,
Cause I don't have my index.
21.
Okay. What does it say?
Every company incorporated or registered under this act shall have in its name painted or affixed and shall keep such name painted or affixed on the outside of every office or place in which the business of the company is carried on, or in the corridor, passage, or hallway adjacent or proximate thereto in a conspicuous position in letters easily legible.
But that ain't in the new one. That ain't in the new act.
Yes.
Where?
What do you mean?
Yes.
It better be
Yeah.
there.
21.
21 in the new York is amount of consideration, for capital and dividends.
No, it-
I'm sorry for that.
You have it right, right? No, we have it, I have it.
I can't read that. I have it in my old one though. Yes, you have it in 21. You have it? You looking?
21 is capital and dividends.
You're an
and
IBC.
there's-
You're an IBC.
No. What is it?
See,
I know.
Sorry, I was in the wrong act.
Where's your company's at?
I don't have the new companies act. I
I'll
only have
print
the
some,
old one.
I'll print some and bring them on.
I can give you my email if you email it to me.
Okay.
Okay, so see? 21. It's required by law.
Yeah, it in the new one.
That's what nameplate means. It's
So
required.
when you go into some of these companies, and you go to some of these law firms and different places, and you see all these lists of companies, they're the registered agents for these
Yes,
companies.
and it's required by law
Okay.
that they put the names there.
Oh, okay,
And if a company has been struck off, you have to remove it.
okay.
But that's different. The nameplate at the registered office different,
Different from the nameplate of the company,
the
yeah.
nameplate.
In,
at the-
yeah,
the little
inside it,
Right,
you put another nameplate and you have the list of companies that you manage by law.
Yeah.
They should. It's a violation.
Yeah.
Especially, like you saying, if they're an FCSP or a bank or trust company and they're regulated, when the regulators come in, the first thing they look at, license, the plates, and is your name displayed? And if it is correct.
Is this for every company that they incorporate or just their
Under the
entity?
company.
Under the Companies Act? Yeah. Remember, under the IBC Act, you're being incorporated by a bank or financial corporate service provider. So whichever one it is, when you walk inside the establishment, there's a nameplate.
So let's say you're a bank and trust companies, and
Mhm.
you have all these IBCs. So once you get inside, the bank,
There's
you'll
a,
see the list of all the.
yeah,
IBCs.
all right there.
Okay.
Uh-huh.
Okay.
Register of members, register of directors and officers, and remember, it's the job of the corporate secretary to maintain all of these things. Whenever they have meetings, there's a director removed, there's a shareholder, a new shareholder, they're the one who have to keep these up to date and make sure the resolutions.
Is this just a position, corporate secretary?
Yes,
Yes.
Yeah.
a highly paid one,
I
That's
just
what I
wanna
just
say.
highly
I
paid,
saw all this stuff dual roles, I
Highly
was
paid.
wondering.
highly paid.
Highly paid position.
Yeah.
Mm-hmm.
And I gotta know all these stuff.
Yes, ma'am. It's the most important one,
Mm-hmm.
because the corporate secretary sits next to the chairman of the board.
Oh, okay.
The corporate secretary prepares the agenda to be approved by the chairman. The corporate secretary puts all the documentation from all the departments together before it's sent out. So the corporate secretary, when we do that in here, you will see, has to have knowledge on a lot of things.
Most times the corporate secretary is like the legal counsel,
Yeah,
or somebody with legal
yeah,
background.
or the legal background. Register of mortgages and charges as applicable. And remember, there's mortgages and charges, you see it in the IBC Act, but remember we just read in the articles of an actual Companies Act company, it says the same thing. It doesn't, in practice, you don't see a register of mortgages and charges going to the board. But you notice that it says under the duties of the directors, that they're responsible for ensuring that mortgages and charges are recorded.
So what is it, do they have an appendix or something attached to
It
the
normally doesn't,
resolution?
no, you normally don't see it,
You won't see it?
no.
Okay.
Mm-mm.
Is it filed
With the mortgages
when you
and
have those
charges?
statements?
Yeah,
Yeah,
yeah, they're filed, but
they're
I'm saying to the
filed.
board, you wouldn't get a sheet to say these are all the mortgages. It's delegated to the manager of credit. So when he says we, mortgages on record is whatever the number is, it's his responsibility to make sure that they're being recorded.
Okay.
And when they're not recorded, then he has to speak to why, because he puts the bank at risk. Declaration of trust, and that'll be for nominee shares if you're under the FCSP. And then the first director's minutes, and then the shareholders agreement.
When you say under the FCSP,
Mm-hmm.
you're saying for the declaration of trust?
Mm-hmm. You know what I mean?
I'm trying to distinguish, okay. No, I think I need clarity on this, on
Okay.
9.
If you establish a company, an IBC,
Mm-hmm.
through an FCSP or through a bank and trust company, the shares are held by that institution.
Okay, okay.
Financial Corporate Service Providers Act. Oh, you didn't know that one either? What do you need to say? Financial Corporate Service Providers Act. So that act is a company that has been incorporated by a Bahamian to provide corporate services to other companies, in
So
particular IBCs.
You can have a law firm acting as a FC.
As long as they are licensed
Licensed,
under
yeah.
the Financial Corporate Service Providers Act. They can act as a director, they can act as a shareholder in a nominee capacity.
So they incorporated to do what?
They're a company and they incorporate under that act
Mm-hmm.
to provide corporate services. I don't like to go too much with these fees, because these fees change every day. Depends on how they feel. Okay, let's go to 77. Let's look at the post-incorporation document, well, at the beginning and then go. So first thing we know is we reserve the name. Prepare your memo and articles for signature. Then you confirm it. Prepare affidavit by witness to the subscribers and arrange to have them sworn and notarized. Prepare a declaration. Then request your check for filing. Request your check for stamp duty. Prepare your letter to the registrar. So all this is administrative work. That's why the attorneys is charged so much. Order your nameplate, your share certificate book, order your seal. Apply to the central bank exchange control for approval of any foreign beneficial owner. Depends on what you come to the Bahamas to do. You may need approval of the National Economic Council, which is the government. Stamp duty to public treasury.
This part you're indicating first is free, right?
Mm-hmm.
Okay.
Yeah. Stamp duty to the public treasury for the authorized capital. Then you have to file your memo and arts, prepare your register like we just say, prepare your initial director's minutes, prepare your share certificates, prepare a letter to send the documents to your clients, an invoice if it's an IBC, prepare your corporate files, obtain your NIB number, prepare your business license registration form. You know that includes VAT. Include your trade name on your business license registration form and obtain your business license. Yeah, it's a long process. Even though in the trading hours is a long process. This is the same thing, recording the name, go into NIB, Environmental Health, then Department of Inland Revenue.
When you say with the memorandums and article, I think you said it earlier. But who do you say sign it? You say the person who prepares it?
The subscribers.
No witness.
Mm-hmm. Then you'll have your first meeting,
Mm-hmm.
and then you would change it.
Okay.
So notice an IBC is a little bit shorter. Certificate of Incorporation, Certificate of Compliance, Memo and Arts, your share book, share transfer form, corporate seal, your management and corporate director agreement, because don't forget, there's either the bank and trust company or the FCSP who's managing everything. So you need an agreement between them and the beneficial owner of the IBC. Register of members, register of directors and officers, register of mortgages and charges, subscriber minutes, appointment of first directors, a nominee agreement, and then a seal log. And that's it for an IBC.
What's a seal log? So-
Because you are the registered office here, the actual seal imprint is here. The actual BO has the seal. So wherever he executes the seal, you have to keep a log.
Okay. So, if the local company here won't have the seal,
No, unless he gets two.
and so how
He keeps
would-
an imprint of the seal.
Uh-huh.
But if he's not the director,
And so if he,
What do you mean if he's not a director? If the beneficial owner is also the director
Oh,
and also
okay.
the signatory is different.
okay, that's
But
what
if
I
the
was thinking.
FCSP is the director and the authorized signatory, then he needs all of it. Because he'd be executing everything. But in most instances, they are not. The BO does it. There are companies like that. I incorporated IBC here. What I want the FCSP to do is to do my filings.
Okay,
I do my own transactions.
so now we're just the agent,
You're just an agent, yes.
and so everything is sent to whoever.
Whatever
authorized.
business they transact over there, they do it themselves.
So once
And
they-
you keep the log as to what he has done.
so he would provide that
Yeah.
information, okay.
Mhm.
So what happens if he's not,
Providing,
providing
what are we
it
supposed to do?
on a regular basis?
Then you'll be like a lot of the IBCs on the record now trying to figure out how in the world you can get rid of them as a client. And they have them. Trying to figure out how they can get rid of them because they are non-compliant. Because you can't, you cannot keep your books and records according to law because they are not giving you what's required to do it.
I have a question.
Mm-hmm.
The corporate agreement and the
Mhm.
nominee agreement, is that definitely two separate documents, or can it be combined as one?
Do you see corporate agreement?
When you say corporate.
Management,
directors
corporate
agreement,
director?
yeah.
It depends. Because you may want the FCSB just to be a director, or you may want them to manage the account and be a corporate director.
Okay.
Yeah. So that's why the part we did before on KYC is important because you have to know who you're doing business for. Because everything out there will be in the name of the SVSP. Your name is out there. Your company name is out there. You are signing on behalf of that company. And so when something happens, you'll be the one who's liable. So what the pressure from the government is getting now is the OECD said that we have all of these IBCs, but they don't have an economic an economic reason or substance to be here. And they want them taxed. So we can have a level playing field for local companies and international companies. So that's why we have the multinational entities substance bill that's now being discussed as to how we establish an economic presence by IBCs in the Bahamas in order for them to be taxed.
That's for us or that's for the international?
For the international community, we are already taxed. Our companies are taxed through business license. But we're gonna have to restructure that because they want a level playing field. They wanna say corporate is corporate, whether it's resident or non-resident. They don't want no one structure here, one structure there, because they're not getting taxed. So that's why we have to spell the name of
But the
no tax, no
the
tax.
tax that's paid can be going to our government.
Yes. So they say all of these offshore jurisdictions have this large number of companies operating out of the jurisdiction. But what are you getting from it? No revenue. Besides the financial corporate service providers who do the registered office and registered agency. But they're saying that they have no economic substance here. And so what that law is seeking to do is to determine what gives you that substance in order to be taxed. So that's in draft right now. Yes, it will. But then, to see the same, it'll decrease the amount of IBCs, but look at it from the opposite side. Each one of those countries is now demanding its citizens to pay its taxes. So you can't run, no matter where you go. So if you didn't do it voluntarily, they will come after you under the Proceeds of Crime Act.
You said the act is, what they're working on?
Multinational Entities Substance Bill, 2018. So that's what we're up against. Tell me what? Oh Lord, here you go again. So that's it for incorporation. Any more questions? 1 second about my more dirty. You play a lot of people. Yeah. Yeah. Some people have it for a long time. No, long enough.
The quiz that's coming up on the 20th. How is
The
it?
quiz?
That's a midterm
That's a midterm exam.
Sorry.
Quiz?
I was late.
Quiz?
How's the structure? Is it acid?
Yes, ma'am.
On the 27th now.
On 27.
On the 27th. What's on the 20th?
I don't know yet.
They changed the midterm, they switched it
The 27th.
to 20th to the, yeah.
Let's switch it around. Chapters 1 through 5.
Chapters 1 through 5.
Essays.
Does it
That's
essay
it.
form?
Like how many essays? That's a
Just
week.
as she does ask, I don't know.
Oh, gee.
Maybe 8 or 10.
You don't know
You
yet?
don't have to do all of them.
Oh,
8 or 10.
you
You
select.
let me choose something like
You
3.
select.
so tell anybody select.
No, you don't want that.
I think I asked. They did.
No, don't want that. If I give you 50 multiple choice at 2 points each, that's 30. So take 30 from 100. How did it leave you with?
70.
You think you can pass?
You like it?
Huh? I think you better stick with short answer.
Man, you ain't gonna get all the multiple choice.
You ain't gonna get all of them right, I can tell you that.
She
But
said
you
we
ain't
get all
get
that
wrong,
wrong.
wrong either. You ain't
Yeah.
get wrong either.
But they be so difficult
They'd be difficult.
sometimes.
So you may get someone
But
who
looking at
gets
some of those
13.
essays stuff in here, they were so vague, the questions.
Yeah, but it ain't gonna be like that.
Let's see.
It ain't gonna be like that. It ain't gonna be like that.
No, you know
Man,
the ones
if you
that are
give
back
us
and
that in the
forth?
word
No.
book and
Let
in
me
big,
have the exam.
the exam could be the same way.
Let me have the
What?
midterm. Would we be able to look in our act and see if we could refer to a section?
No,
Would
then
we
you
be
don't
able-
want open book. Open book test designed for you
No,
to
I'm
see.
not asking for open book, I'm saying just for the act. For you to say, well, section so and so of the act. We have to memorize those sections.
You don't have to give
No,
me the
just
number.
refer to that.
Oh,
Just refer to the app.
okay.
Yeah, like the company act or the
Just say the
IBC
company
act
has
and
what
then-
IBC
okay,
act.
then
Yeah,
we'll-
you don't have to, I don't need the sections. Cause as you can see, my own say
She
one
get one
section
section,
and
we
yours
get
have a
one
different
section.
section.
That's right.
So I never ask for the section, that's why I don't do the fees.
So we only have maybe 1 or 2 essays to do.
No, short answer.
Short answer, or short
So you probably do about 4 to 5. You have 3 hours.
So we're gonna have 3 hours.
You have the whole 3 hours. You're from 12 to 3.
What day is this again?
Exercise your brain. The 27th.
3 hours, yes.
You know you could do it in 30 minutes.
I'm working on this since ASBO coming their high level meetings, yeah, the 29th, Friday, 29th.
So you'll have your exam before that. See you next week.
Natasha, I have a
Bye.
question. So
Mhm.
say you and I'm with Lisa Matt. Since I can't make on the 27th, day through the week.
27 is on a Saturday, so anytime during that week.
I can negotiate.
Huh?
No, I need to know because I got to take some time.
You tell me. You could tell me next week so I can put on my calendar the day you
Which
come
day?
in.
So I could just pick any, I
Yeah.
can look at that weekend, see
Uh-huh.
which day.
Not Friday.
She could be away on the 27th.
So the two of them can take it
Not
together.
Friday.
No, because they don't be here late on
Okay,
Fridays.
so, oh, it'll have to be in the afternoon, you tell me.
You can do it in the day.
And you're working a day? They working?
Up to her.
No,
They take a day
I
off.
could take a day.
Okay, so you just tell me which day
What day and
Yes.
I just want to know what available for you. So Monday to Thursday
of the same week.
of the same
But she
week.
chose-
What you're saying I could select in the day as well.
Uh-huh.
Okay, because I'm thinking I might do it first thing in the morning. like
That's
at
fine,
9
you just
o'clock.
tell me.
Okay.
What happened is I'm traveling from Thursday to Sunday.
Okay, so y'all could do it together. Monday, Tuesday, or Wednesday.
I'll look maybe at that Wednesday because I was thinking of that Thursday.
Yeah.
I was
Wednesday.
thinking of
In the
that.
morning?
Wednesday, in the morning. What's the length of the exam?
3 hours.
3 hours? So what time would be the starting time?
To me, I think 9 o'clock is 9 to 12 might work for me. in the
9 to
morning.
12?
Yeah. So if you're looking at it, I'm thinking since she can't do that Thursday, if you want us both do it at the same
On
time.
Wednesday?
it
Wanna do it
might
on
be
Wednesday
that
morning?
Wednesday.
Wednesday is good.
9
Could
to
we do it
12?
in the afternoon?
I can't do afternoon.
She can't do
I
afternoon.
No, I deal with people with cash and I really can't set a time for that.
Oh, yeah. 'cause
That'll
she
be
could
my
go on
issue.
over.
Alright, well then 9 o'clock.
And these
9
people
o'clock
can't
on a
come in
Wednesday?
balance.
Yeah.
Okay, alright.
That'll work then.
Yeah, so Wednesday at 9
Cause
o'clock.
I was
That
trying
can
to
work for
prepare
me.
for the
Okay.
20th anyway, so.
Yeah,
Cause
that
I remember
can-
you said 20th when you changed it.
Yeah.
Yeah, so Wednesday morning, I guess
Because then we had she just joined,
uh-huh.
and we had 3 other people join the
Yeah,
week
they need
before
to
that.
be
So
honest, I'll
when
be
I thought
fine.
about it, I said it's best I push it back to give them enough time to read.
And that's fine for me, so I mean, the Saturday I wouldn't miss nothing
No,
because
you
y'all
wouldn't,
doing
no.
class.
Right.
The 27th, because when
Uh-huh.
I come back that morning, so I'll make 12 o'clock on the
Yeah,
3rd.
okay,
Yeah, so
good.
that's fine with me, but Wednesday morning
Mm-hmm.
at 9, so you just come here in 3 hours.
Yeah, let Miss Dean know you're taking your exam on the 20th now.
Okay.
No, Miguel. Tell Miguel, if he's there. If he's not there, tell him. That's the 25th. Not the 20th, the 27th.
The handout that you gave out last class, do you have any more copies? Or no? I'll have to get that.
Get it from one of them. You have yours?
Let me look, I'll have to look. Please get so much copy, I can't, it would be hot.
Cause I know we I was in that class, that's when you went over the proceeds of crime after 2018
Oh, that's what we
one.
went through, we
Yeah.
printed them.
Okay,
We
so
got
I have
them out.
2000, so it's just the 2018.
All the laws
All
changed.
the- all the
the laws
ones.
changed.
Okay.
Yeah, but we
Proceeds
got
of
them.
crime, Financial Transaction Reporting Act, the regulations, the wire transfer, anti-terrorism, they're all 18.
Child, if you say we didn't get any handouts.
I'll have to go
No,
through all of
because
them.
everybody brought it.
Yes,
But
but
I think a list of them is in this same.
to let you, oh, they said Miguel left,
guidelines.
Oh,
so.
I'll tell him.
Okay
I'll
then.
tell him. I'll send him an email as soon as I get on.
Okay, thank you.
Okay?
Okay, bye.
To make sure. Yeah, everybody had their own already prepared.
Okay, so all of this, because I was reading this as well, this one here.
Yeah, that's just
And
the
it
guidelines.
It has
yeah,
all the
these.
laws that were amended and changed.
Yeah, you don't need this one.
Not this one.
All of these, they've
Okay.
already gotten theirs and bind it.
Okay, I can just deal with those. I have some of them already. I write books where you got last time.
She's going to the event, is it? Oh. You're traveling for a week.
What happened is my daughter at the tournament.
Oh. I mean, kitty leaves.
When is your thing up your
my page. 732. Where's 1? Okay. Okay. Let's wind out.